So panic often occurs whenever a new piece of legislation is proposed. And especially if it's around the eviction space, if it's around the financial space, maybe it's expropriation, there's usually a lot of panic that follows this. The only reason why we have conversations around these proposed bills is that people understand what the intention is, and we manage the situation and manage the client's expectations. Now, in our particular industry, especially when we're dealing with rental evictions, it's important to understand how this bill could impact us going forward. Now, the first thing that you need to remember is this is a proposal. It's still open to comments. So comments can be submitted. Comments are going to be submitted by myself, by fellow law firms, but any individual, any property owner is welcome to submit comments too. Second thing is we need to understand the possible implications first before we panic, and we need to understand whether this worsens our position or improves our position as landlords. So under the current circumstances, I haven't studied a bill in a lot of depth, simply because potential changes may still come about. But from the comments that we're considering submitting, we've looked at four aspects. And now the first aspect is the just and equitable requirement for all occupiers, as opposed to simply considering the different types of occupiers. There was a time period of 6 months, and the courts would look at the first 6-month occupier differently to the second 6-month occupier. And the reason why they've removed this now is because of the Constitution, the fact that everyone under our law needs to be considered equally. Now, unfortunately, from an eviction perspective, this means that any occupier, their needs now have to be considered outright, even in circumstances where previously you'd find that the people that were there for shorter periods of time would be dealt with differently. This, I don't anticipate, will change. I think this is something that we always asked about, that 6-month period, never quite understood why it existed. So I do believe that this is something that will probably be retained in the Act. But again, this is completely speculative. And from a landlord leasing perspective, not really something that we find impacts us in our litigation all that much. Similarly, another one is the fact that now there's an additional party that needs to be added into the litigation process, a joinder. This, unfortunately, I feel is going to add a layer of complexity and delay, because now it's another government department, the Provincial Department of Human Settlements. And what we do know, unfortunately, is because there is a backlog with a lot of government departments, and there are situations where they cannot react fast enough. Adding another one to the process seems, unfortunately, to be hindering the process as opposed to assisting it, despite the fact that it appears that this bill was introduced for the purpose of apparently avoiding future delays. I cannot see how this in any way will avoid a future delay, but I would love to see how the Department of Human Settlements approaches this, and whether they have any comments that they're going to make as to their involvement now and what is expected of them. Other change is now they've written in a potential compensation for improvements done to the land by the unlawful occupier. This has always been a thing in our law, though. There's always been a lien that an occupier is entitled to exercise in defense to a claim for eviction. But remember, this doesn't necessarily entitle them to live and enjoy on the property. It's more a possessionary right. And this has always existed. So this appears now to have been inserted into the legislation, and quite a bit of analysis needs to be done as to whether this is simply a codification of our current law with respect to liens, or whether this is actually now a supplemented right that entitles people not only to possession, but also the enjoyment of the land, and not being evicted until they get paid out for any improvements to the land, because this is obviously usually a contentious issue. As those, in my mind, comprise the most important amendments that I saw that jumped outright. We will obviously be preparing quite a few comments and doing a lot of these talks as we go along. But again, for now, this is speculative. These are the primary amendments. Does this impact the landlord in the rental space? Yes, but not as much as you think. We have control mechanisms that we've dealt with that basically allow us to deal with situations like this. So, for example, compensation for improvements. Please bear in mind that there's a reason why the lease agreements we suggest that you use have certain contractual provisions in it that take away that entitlement of an occupier that decided to go improve land without consent, despite the lease agreement specifically requiring consent before any improvements are made. So if you're a landlord, if you're using the right lease, if you're using the right rental agent, this will not impact you as much as you think. But again, we're yet to see, and as this develops, we'll keep everyone abreast.